नमस्कार, आदाब, सत श्री अकाल दोस्तों। स्वागत है आपका एक बार फिर से हमारे YouTube चैनल ब्रास फ्यूजन्स पर, जहां हम आपके लिए एक बार फिर से लेकर आए हैं एक नया लेसन।
Over and above, all these other aspects can also be treated. So all this is treated as part of executive power. And if I were to take the president as the first person in whom is vested the executive power, the president specifically, not just the executive power of the union, but the power of the president. These are two slightly different things. What we have looked in Ram Javaya Kapoor's case is the executive power of the union. But the president also has some powers, and this has been a subject matter of great legislation, whether adjudication, whether the powers of the president are distinct and separate from the executive power of the union. We're going to answer that when we come to Shamsher Singh's case. But for the moment, let me just tell you that the president has the power of appointment of the prime minister, the president appoints the governor, the president appoints the CAG, the president appoints the Lokpal, so many things the president. The president also summons and dissolves the houses. So if you were to look, for example, at Article 85, he summons the house after the first election. Under 108, the president dissolves. The president makes an opening address when the general elections are done. If you look at Article 89, the president summons the joint sitting after the thing. Every year, the first session of every year, the president addresses joint sitting. Article, I think it's 86. President also nominates people to the Rajya Sabha, 12 people to the Rajya Sabha. Anglo-Indian used to be there. Okay. The president also issues ordinances. The president also gives prior sanctions to certain legislation. Article 255, Article 255 says that in the concurrent list, if the parliament has already legislated, you need prior consent of the president before the state will move another bill on that concurrent list. Similarly, there are certain money bills under Article 111, Article 201, etc., where President issues proclamations for President's rule for emergency. Now, how does the President operate? Does he operate separately or not? Had been for the 1950s and 1960s a little bit of a grey area. So there are two further questions now that I'm looking at. The executive power of the union, and then these powers that are exercised by the president. And to find out the answer, whether they're separate or together, and what exactly it means, we turn back once again to Article 73. Yeah, president does many things. Yeah, age of dispute. President also, if you look at Article 103 about qualifications, etc. That's the election commission. Yeah. Now look at 73. So there is a listing, okay? All these textbooks will tell you fully. I think I've mentioned that. Now look at Article 73. 73 tells us, I'm now looking at 73 and 74 for the remainder of the class. 73.1. Subject to the provisions of this constitution, the executive power of the union shall extend. Now we're talking about executive power of the union. Shall extend to matters with respect to which parliament has power to make laws. We've been over this. It is coextensive with the powers made over parliament, but it is not exercised through a parliamentary law. The distinction we have made clear. There are some occasions where parliamentary law is necessary, but otherwise we are only delineating the area or the extent over which you have powers. The exercise of such rights, authority and jurisdiction as are vested by the government of India by virtue of any treaty or agreement. Any right that is given. For example, immediately after India became independent, one of the earliest treaties we entered into was the Indus Water Treaty with Pakistan. And you know that in the Punjab there are the 5 rivers and Indus. Indus, Chenab, Jhelum, Satluj, Ravi, Beas, right? And Satluj, Ravi and Beas completely in India's scope. We are free to build as many dams as we want, even though both India and Pakistan are riparian states. Riparian, just a nice little word under international law where the river flows. Okay? So the Indus Water Treaty, but we don't control the water of the Indus. I mean, for day-to-day purposes, people living along the riverbanks can take, but we cannot build a dam along the Indus. Chenab and Jhelum. Okay. So Satluj, Ravi, Beas totally ours. Okay. And therefore Pakistan has built the dam on the Indus River. So this Indus River Water Treaty, okay, and for those of you who are interested and are wondering what, this is a very interesting area truly. It was one of the earliest treaties that we entered into immediately after India became independent. And it was a very important treaty also, the selection of rivers, which would serve the Indian interests more. And because these 3 flowed through Punjab, the earlier undivided Punjab. So the choice of rivers was also very important. And so the Satluj Bhakra Nangal Dam, the legal basis that India has to build and dam that water, all flows from that Indus River. Okay, now anyway, for your interest and your reading later. Now, so the rights and authority and the jurisdiction will flow from that. Now come to the all-important proviso. Provided that the executive power referred to in subclause A shall not, save as expressly provided in this constitution, extend in any state to matters with respect to which the legislature of the state also has power to make laws. What are we talking about here? The concurrent list. That in the concurrent list, if the state has a power to make laws, can Parliament or can the executive power of the Union extend or not? And there are 2 words here. Save as expressly provided in this constitution or in any law made by Parliament. So there are these 2 saving clauses. Unless it has been specifically mentioned otherwise in the provision of the constitution, or unless it has been provided otherwise in a law made by Parliament, generally speaking, where in the concurrent list, where the state also has the power to make law, not that the state has made a law, it merely needs to have the power to make a law. In that concurrent list, it may or may not have made a law. In that concurrent list, if the state has a power to make a law, then the union power of the executive power of the union does not extend there. But what is very significant is the 2 saving clauses that we have in the proviso. Except as expressly provided in this constitution. And there are many constitutional provisions where laws can be made. For example, if you look at Article 246, 249, 250, where Parliament can make laws. And when it makes laws, it can also say that the power of implementation or the power to make rules will be given to the union government. It's possible to have laws like that. For example, I took the example of the MNREGA. Under the MNREGA, the fixation of wages is done by the appropriate government. but other rules are made by the central government. There are many central acts where the rule-making power has been given entirely back to the. So, Labour, for example, is in the concurrent list. But if centre makes a law, of course, now starting from yesterday, I'm just thinking that all the labour law and our syllabus has to completely change. Even industrial law has to completely change now, because now once the president signs, all those older laws go out. I was just thinking yesterday, my God, we have to change our syllabus quickly. Anyway, but the important point is that if Parliament makes a law and it decides to keep executive power with itself, then notwithstanding that, under the proviso, executive power will be retained. There are other provisions of the Constitution. For example, if you look at 258A, under 258A, the governor of a state may decide that the executive power of a law made of the state may be transferred back to the centre. An order could be issued, a notification could be issued under Article 258A. So there are many provisions in our Constitution where the power can be transferred back to the state. Now, the most litigation with regard to this proviso has happened with respect to Article 72. When a person is convicted under a criminal law, for example, and he is undergoing imprisonment, who has the power to order pardon or to give parole or to give remission of that sentence? So if you look at the number of cases that have come before the Supreme Court, maximum have come under this proviso from criminal law. Okay, so I should actually take criminal law cases. And in 2015, there was a very interesting 5-judge bench decision. Union of India versus Sriharan alias Murugan. Let me just type it so that you have it here. This is actually the Rajiv Gandhi assassin case. This person was undergoing life imprisonment and he applied for remission, which is a power to, suspension of sentence, reduction of sentence, etc. Wanted remission. Now the question was, who has the power to grant this remission? Should it be the central government? Should it be the state government? And the power of pardon or the power to grant remission under Section 435 of the CRPC is given by either the central or the state government. So which is going to be the appropriate government here? That's the background to which, and what was under discussion was the 2015, do I have the citation? It's SEC. It just sort of is fine. I can't find it. I have it in my notes somewhere. I can't find it here. And what the Supreme Court tells us is that if you look at the proviso now, once again, provided that the executive power referred to in subclause A shall not, save as expressly provided in this Constitution or in any law made by Parliament, extend in any state to matters with respect to which the legislature of the state also has the power to make law. So what the court says is that if the person is convicted by a central law made by Parliament, then the appropriate government to give remission, etc., will be the central government. But if the person has been punished by a law made by the state, then it would be made. So that's the way in which we would need to interpret this particular proviso. So therefore, it is not as if just because the state has a power to make law, executive power will go with the state. Those two saving clauses, either expressly provided in this Constitution or by a law made by Parliament. So in criminal law, which is actually the place where bulk of the cases under Article 73(1)(a) proviso come, it depends on whether the conviction is under a central law or a state amendment to a central law. If it's through a state amendment to a central law, then the executive power would be that of the state. And the second reason for so holding is Article 162. I'd like you to look at Article 162. Look at 162 and see how the two are tied together. Subject to the provisions of this constitution, which means that 162 must be read subject to 23. The executive power of a state shall extend to matters with respect to which the state legislature has the power to make law. List 2, list 3. Now come to the proviso. Provided that in any matter with respect to which the legislature of a state and Parliament have power to make laws. So we are talking now about list 3. Provided that in any matter with respect to which legislature of a state and Parliament have power to make laws, the executive power of the state shall be subject to and limited by the executive power expressly conferred by this constitution or by any law made by Parliament upon the union or authorities thereof. So the executive power of the state will first yield to what the constitution says. And I refer to 249, 250, I refer to 277, where sometimes, these are taxation powers where under the constitution itself, the executive power has been given to the state. Under 258, executive power of the state can be transferred to the center. So those are express provisions of the constitution, or by law made by Parliament. So if Parliament makes the law on a concurrent list and takes unto itself the executive power, then the executive power will not extend to the state. So that phrase, over which the power of a state to make laws, appears very broad, but it is limited by the proviso under 162, read also with the proviso under 73(1)(a). So therefore, don't go only by a phrase. What as students of law we need to do is to read it in its entirety. And because 73 says subject to the provisions of this constitution itself, we are permitted to look at 162, which itself cross-refers back to 73. And we know that again here, there is a great privileging of the power, executive power of the union, which can be claimed through legislation. So 73(1)(a) and the proviso, I'm now making a slightly different point. 73(1)(a), it's coextensive. I told you, Ramjavaya Kapur, I said it can operate even in the absence of legislation. Proviso makes it clear that if there is a legislation and it gives you expressly that executive power, then that will be an additional executive power that you would have, particularly when it comes to the concurrent list. So in matters relating to concurrent list, and the more important matters in the concurrent list are some criminal laws, are the labor laws. You need to see what exactly Parliament has done. Now, I've not had chance to read these three legislations. I'm still in the process of looking at it because they've been quite dramatically changed to the bills that I saw of 2019 last year, which went before the Standing Committee. I had been following that quite closely. But if we, I'm talking about the labor codes, but if we went to the earlier laws, the earlier labor laws, Industrial Disputes Act, rule-making power has been given to the centre. But when you come to, for example, building and construction workers, child labor laws, rule-making powers have been given to the state. Powers of implementation have been given to the states. So it depends on the nature of the law made by Parliament in each case. So let me just draw together my threads of what that we've looked at. We've looked at to see what is the executive power, Article 53, and then we looked at Ramjavaya Kapur that there's no positive definition of it here. It is the residuary after you take away executive and judicial powers, and it comprises at the very minimum the determination of policy, the carrying of it into execution, the initiation of legislation, social and economic welfare, foreign relations, so on and so forth. But this is an inclusive category. You can keep adding to it. What is the extent of it? These both aspects, individually we've identified. What is the extent 73(1)(a)? Then we come to the proviso that it also, who has executive power over the concurrent list? The answer is to be found in the proviso to 73(1)(73). And that concurrent list normally goes with the state unless Constitution has indicated otherwise and unless Parliament by law has arrogated to itself that executive power. Now, let me now move on to my next point. This executive power is vested in the President. So we have seen what is the extent of this power, what happens in the more tricky area of the concurrent list, and we have seen instances of it mentioned in the Ramjaya Kapoor's case. Who is it vested in? 53(1) tells us it is vested in the President or in officers subordinate to him. We had a quick look at what that means. How does the President exercise this? Is it exercised by the President in his personal capacity or not? Now, for that, we look now to Article 74. Okay? So just keep it logically in your mind how exactly these issues and propositions are flowing. Now let's look at 74. And 74 says there shall be a council of ministers. Please note the word cabinet is not there. We're using the word council of ministers. And let me also make one more point. There is nothing in our constitution which tells you that there is a cabinet minister and a minister of state. There's only one equal council of ministers. So where does that come from? Is a question. There shall be a council of ministers with the Prime Minister at the head. Okay, look at that nice word, at the head. Okay. British constitutional law says the Prime Minister is first amongst equals. It sort of constructs this non-hierarchical cabinet where he's just one amongst equals. Primus inter partes is the nice Latin word that is used. First among the equal parties. But here we are using a slightly more hierarchical word. He is the head. So, and I think that Indian constitutional theory reflects this greater hierarchy that we have in our constitution compared to British constitutional law. To aid and advise the President who shall in the exercise of his functions. Look at this word, not in exercise of his executive functions. All his functions shall act in accordance with such advice. There are functions of the President. We have seen that the President has powers of an administrative nature where he appoints various people. He issues ordinances. He appoints people to Rajya Sabha, Lok Sabha. He is the head of the military. Therefore, he will also declare wars. He will sign contracts. He will sign treaties. All these things the President is doing. Now, in all these functions, he is to act in accordance with the aid and advice. Now, the interesting legal question to us is, does the President operate in every one of his functions on the aid and advice of this Council of Ministers? Or is there an area of what we could call presidential discretion where he acts on his personal personal discretion? That's right, personal discretion. Or is he always under the aid and advice of this? Number two, a corollary to that, when you say aid and advice, does it mean that you are bound by this aid and advice? Is it like that word consultation, or does it mean concurrence? If it is only consultation, remember we looked at that word consultation in Article 3 of the Constitution, where you take the opinion of the legislature of the state when you are changing the area's name and boundaries of the state. But you're not bound by it. You heard them. Is it that you only give a hearing? So what is the meaning of aid and advice? And where is there an area over which the president has? Shamsher Singh is going to be a very important case that we are going to study for this. Now look at the proviso, which has been inserted by the 42nd Amendment. Provided that the President may require the Council of Ministers to reconsider such advice, either generally or otherwise, and the President shall act in accordance with the advice tendered after such reconsideration. Which gives a part answer to the question I asked. If you can ask the Cabinet once again or the Council of Ministers to reconsider the matter, that itself indicates implicitly that you are not bound by that advice. Because आपने नकार दिया उस advice को, आपने बोला फिर से सोचिए इसके बारे में. Okay? But it tells you that second time around when the advice is given, you shall act in accordance with such advice. Shall act in accordance. There had been a grey area of constitutional convention. 42nd Amendment has now put it beyond the pale of any controversy. He shall act. No discretion, mandatory. Number 2, 74 subclause 2. To question whether any and if so what advice was tendered by the ministers to the President shall not be inquired in any court. So, our entire case law with regard to President's rule is the development of law about this word advice. What is advice? When the President issues President's rule, which part of that advice is now not open to judicial scrutiny, which is not bound to be shared by the litigant, which can be put in a sealed cover if required and shown in a court, or which can never be put in a sealed cover and never been seen by a court. So the question of what is the privilege between the advice of the government to is all under Article 7. Okay, I find that I've now run out of time, so I'm going to stop. Yes, Nirpanshu, I will stop. Thank you. I didn't realize. So I've already taken attendance. So those of you who have not taken attendance, just Vijay 733. The rest of you can leave, please. 733. Yes, Vijay, I've marked you. Who else? No, slowly. Just find out whether I am calling you out, then you leave. Okay, Vijay Pratap, I've done yours. Ankit Kumar, 832. Yes, I've done yours, Ankit. Nikhil, 731. Nikhil, I've done yours. Okay, then Surbhi, 163. Surbhi, I've done yours. Okay. Then Chetna Gupta, 630.
दोस्तों, ब्रास फ्यूजन आशा करता है कि आपको हमारा लेसन पसंद आया होगा। कमेंट बॉक्स में अपना फीडबैक देना ना भूलें।